or a public body. This should bear the meaning it had in law. Government and public bodies are described as their law officers, but nevertheless they are professional practitioners. It is for this reason the court said that the Bar Council of India and Rule 49 of the BCI rules in its original form in the saving clause waived the prohibition imposed by the said rule against the acceptance by a lawyer of a full-time employment. Look, judges, even subordinate judges, when they become judges, they cease to be advocates. They are not on the rolls anymore. Their sanad is suspended. So they can't be considered members of the bar as long as they are judges. Then in Sushma Suri, a three-judge bench of this court, and then Sushma Suri set out in para 92. Their lordship not summarized that. And then where there was some slightly differing opinion, the lordships of the three-judges bench reiterated the legal position.
Before the court was as to whether the public prosecutors, government advocates are entitled to be treated as advocates or not.
In Sushma Suri.
The EPPs also cancel their sanad. They are in the regular roles of the state government.
Sushma Suri dealt with public prosecutors who are appearing in court.
No, public prosecutors, APPs, in Kerala it is called assistant public prosecutors. They do the criminal prosecution in the magistrates court and all that. They are in the regular employment of the government. They cancel their sanad.
But perhaps that may be so as the Bar Council.
Cancellation of sanad is not a very big issue.
I bow to the court.
Especially looking at UP state law officers as well.
I can't take exception to that because I'm not familiar with the Bar Council rules in Kerala. My submission is that the Supreme Court has said that those who are actually practicing law in courts, whether they are on the rolls of a government or not,
they cancel their sanad. They appear in courts as prosecutors, but they don't wear the band. They wear a tie and a coat.
I see.
So the assistant public prosecutors in regular employment cancel their sanads.
Someday your lordship may need to consider whether they are eligible or not.
They are already eligible.
Yes, so as per Sushma Suri, as per the judgment in Sushma Suri, they are clearly eligible if they are actively and on a regular basis practicing
in a court, but only in magistrates court.
No, then in paras 85 and 86 of this judgment, I think that is also dealt with. No, if your lordship kindly sees the para 85 at page 4368, that may answer that point. He holds the post, yet he is not in. So, that para 85, after setting out Johri Mal, then overleaf at 4369, just after that extract of Johri Mal, it says, as regards public prosecutor, this court has consistently held, Placitum A, my lords, on 4369. As regards public prosecutor, this court has consistently held that though public prosecutor is a holder of public office and he holds a post, yet he is not in government service as the term is usually understood. Despite these differences, for the purposes of 233(2), there is not much difference in a public prosecutor and an assistant public prosecutor, and both of them are covered by the expression advocate. It is so for more than one reason. And then their lordship set out those reasons. But we are not really concerned with that. I'm only saying that so far as these two streams are concerned and that there could be a reservation for the members of the bar, that the view taken by your lordships, 1985 onwards, right through till 2013, several three-judge benches. That's I was only trying to place that point. On that, lords, in my note, in my written submission, which is the first one in volume 2, the first one in volume 2, I've set out the very first section at page 5 deals with the principle of stare decisis, and 3 Constitution bench judgments which dealt with that. Volume 2 in my note. Sorry.
volume 2.
No, but the rule over there, let's not get into.
Page 5.
Volume 2, page number 5.
In Deepak Agarwal, there is
Volume 2 is a submission, written submissions of the respondent, so to speak.
in Deepak Agarwal, my lord, there is one paragraph which is important, which is paragraph
Uh,
51.
Deal with it in your own turn.
Ah, very well. Where they hold, my lord.
You have already shown that para.
No, Deepak Agarwal, I didn't touch at all. Para 51 is the relevant para where they presume that 233(2) excludes the appointment from the judicial service. That which is incorrect, not borne out from either of the two constitutions.
Paragraph?
51, my lord. Last 5 lines or so of that. Even though this was not the issue in that case, the only issue was whether public prosecutor, but somehow they've come to this conclusion without saying how.
But none of the judgments considered Rameshwar Dayal, wherein the appointment of Swani and Harbal Singh, though at the time of their appointment were in service, has been found to be valid under 233.
I'm sorry that at
None
that
of
time,
these subsequent judgments consider the position that in Rameshwar Dayal, the Constitution bench has found that the appointment of Harbal Singh and P.R. Swani, who at the relevant time were holding some post,
Yes.
was also valid under Article 233.
Ani's son was also suspended.
So,
It's recorded.
they are not on the roll of the, both of them were not on the roll of the bar association on the date of their appointment.
well, my learned friend, Mr. Gupta would answer that. I just want to, if I can move on and just conclude these aspects. So, what I've set out,
Your main argument is for last 60 years, an erroneous position has been
no,
held.
quite so,
And
not,
this court should not change the same.
yes, not erroneous.
The erroneous is or
An interpretation,
supplementary.
an interpretation which is in keeping with Article 233, according to me. Article 233 provides for 2 sources. Now we come to the rules. So now I'm coming to the next point.
The rules, how can we while
I'm not, I'm on the statutory rules, unless your lordships find that those rules are ultra vires in the constitution and strike them down. That is the point. So, lords, I have set out, lords, at from page 5 onward, lords, the doctrine of stare decisis, and your lordship may just come, lords, to Sharp Hazel judgment, lords, which your lordship will find is in, lords, volume 5.3.
we are not going to unsettle the position which has been holding the field till now. We are not going to set aside the appointments of the persons who are already in appointment also. Whatever we'll be holding it prospectively from the date of our judgment.
I'm on that. Lords. I'm saying that this position with regard to these rules. Now, Lords, so your lordship may only make a note that from page 7 to which page of my Lord, written submissions, I've set out, Lords, the principle of stare decisis with extracts from 3 judgments, including Sharp Hazel, Lord, which is a Lords, 3 paras 17 to 19 of Sharp Hazel, and Sharp Hazel judgment is also in volume 3 at page 1034. Volume 5.3.
Which judgment?
Shah Faisal, no, that was a judgment of a constitution bench. My lord, the Honorable Chief Justice was also a member of that bench. Was where the issue was whether those two judgments, Sampath Kumar and in court number 3, whether Sampath Kumar should be referred to a larger bench, two judgments of the in the context of Article 370. Yes. So if your lordships come to page 1047.
You already quoted the paragraph.
Para 17 to 19 of this.
You already quoted in your.
Lots are noted that. So that may just be.
Last week also I have relied on there it is in that judgment from Haryana.
Yeah. Now, my lords.
There the situations were different. Over the last 20 years, on the basis of a law laid down in Gurjan Singh, the transaction had taken place, the partitions had taken place, and therefore, in that context, here, even if we hold either way, we are not going to judge the appointments or the whatever finality has.
No, quite so. I'm submitting that your lordships ought not to vary this interpretation of the Article 233 in consonance with the rules, which has held the field.
Even if it is on an incorrect interpretation
If
of the two constitution benches.
No. If your lordships find that that the interpretation placed in Satyanarayan independently of the constitution benches, I'm submitting that interpretation is a perfectly valid interpretation, even independently of the constitution benches, which will be made good. But come for a moment.
The law, as we understand, is that the judgment of 5 judges is binding on 3 judges, and 3 judges binding on.
But the five judges have not said anything contrary. So now let me just make good my second point. The point is that Article 233 only prescribes 2 sources of recruitment. This point is very important. My lord, may kindly make a note of it. Article 233 provides for 2 sources of recruitment, but does not provide for the method of recruitment or the manner of apportionment between the 2 sources. That is left for the High Courts concerned in consultation with the governor in consultation with the High Court to make rules for. Now, in that context,
Yes.
so the point is, I'm not now saying that 233 should be interpreted in the context of the rules. I'm saying 233 requires that rules be framed for the apportionment and for the method of recruitment. 233 has nothing in it about the method by which those 2 sources will be operated. Nothing, zero. Now, please see, my lords, your lordships have over a long period of time taken the view that so far as the method of recruitment and apportionment of posts between different categories are concerned, that is exclusively the purview and prerogative of the executive. In this case, the High Court, I would say. I would substitute the executive by the High Court. So please see, my lords, the Constitution bench in Bishan Sarup Gupta, Lord, that judgment is not in the compilation. 1975, volume 3 SCC, 116, I'd asked for the books to be called. 1975, 3 SCC 116. 1975, 3 SCC 116, Bishan Sarup Gupta was the Union of India. 116. 1975, 3 SCC 116. Now, here the promotees contended that though the Supreme Court had asked for a rule to be framed, that rule was unfair to them. That contention, your lordship will find in para 16 at page 127. and then come to para 17. Lord. Para 16 just sets out that their contention was that though Supreme Court directed rule to be framed, that rule was unfair to the promotees because it didn't give them sufficient weightage, etc. Now, para 17, the Constitution bench said, when considering, may I read that was page 128? When considering this point, it must be clearly understood that this court is not concerned with the government's policy in recruiting officers to any service. Government runs the service and it is presumed that it knows what is best in the public interest. Government knows the caliber of the candidates available, and it is for the government to determine how a particular service is to be manned, whether by direct recruits or by promotees or by both. And if by both, what should be the ratio between the two sources having regard to the age factor, experience, and other exigencies of service. Commissions and committees appointed by the government may indeed give useful advice, but ultimately it is for the government to decide for itself. In the particular service with which we are concerned, class 1 income tax officers, government had known for many years, there was a lot of discontent, etc., etc., etc. I'm asking your lordships to read the High Court and the governor in place of the government here, governor in consultation with the High Court. Now, this is the principle which has been followed, and I'll give the citations, Lords. These judgments are not on record because this issue of quota only fell from your lordships in response to argument made by the other side orally, that how can a quota be framed if it is not in the Constitution in Article 233. So I'll just note, if I can tell your lordships that this has been followed, this principle is followed, Lords, in Dwarka Prasad, that is 2003, volume 6, SCC 535. Dwarka Prasad, 2003, volume 6, SCC 535.
1 minute. 2003,
volume 6, SCC 535. 6 SCC 535, Lords. We just handed up the book, Lords. And look, para 16 of this judgment said that where there are different feeder cadres, may I read that? It's a very short para. Para 16.
So we are not going into the rules. The rules here, they are framed only on the basis of the judgment of this court.
So, first of all, power. No, I'm on the source of power.
We are not disputing that the High Court has the power to frame the rules.
No,
If the rules are framed only on the basis of the judgment of this court.
No, the query fell from your lordships with regard to how can a quota be framed if it's not prescribed in 233. I'm submitting that the quota does not emanate from 233. 233 lays down two sources. Now, if I can just show your lordship para 16 of this judgment, it's a little important. Their lordship said, and this is on the same lines as what the Constitution bench had said in Bishan Sarup. Para 16, fixation of quotas or different avenues and ladders for promotion in favor of various categories of posts in the feeder cadres based upon the structure and pattern of the department is a prerogative of the employer, mainly pertaining to the policy-making field. The relevant considerations in fixing a particular quota for a particular post are various, such as the cadre strength in the feeder quota, suitability more or less than the holders in the feeder post, their nature of duties, experience, and the channels of promotion available to the holder.
I think we have not made ourselves clear to you.
I'm sorry, Mr.
We have not made ourselves clear to you. There is no question of quota here. What we are trying to tell you is this. As we have given the example, if 10 posts are there, 7 are earmarked for promotion, there's no way that a lawyer can advocate or a pleader can get into that.
Yes.
That's a separate channel.
Yes.
So where the water will travel, separate water will travel on the travel channel.
Yes.
Which means the remaining 3 is not a quota, it's the only category to be decided on merit. The question is, now can the remaining 3, which you have to 3, forget about the 7, you take this remaining 3.
Yes.
That is the appointment, the appointment you made up for 3. Can in the remaining 3, can you exclude this? There is not a question of quota here.
Yes, my answer to your lordship is yes.
7 is.
It can be reserved in its entirety.
One mode of recruitment, you are not eligible. You are obviously not eligible, you go out of it.
And
In the absence of any eligibility fixed for you to the exclusion of others, you can't stop. That's a very simple question we are putting it to you. Therefore, no question of quota being carved
my
out, this and
answer-
that. Don't go with the larger issue now.
no, my
You
answer,
don't bring the promotional post into this.
no, my answer to your lordships is yes. That can be kept only for the,
That's why we say under the constitution, see, there is no bar. See, that's why we repeatedly were telling you, probably you may have a case, let us say that out of 3, they also apply. In that you give a reason for making adequate analysis after considering the material available. Then you say for A or B reason, we would like to give 2 to the lawyers and leave 1 to the open category. That is something which is different. But yes, the Honorable Chief Justice was saying that is not the way it's been done. It is just on a complete misconception of prima facie, subject to hearing them
No,
on Article 233.
may I answer that, Lord?
Yes.
The 75% didn't,
We are clear on this.
yes,
Yes.
let me answer it, Lord.
Yes.
The 75% didn't fall from heaven, Lord.
Yes.
The 75% was not like Moses coming down from the mount with a carved in stone, that 75% is to be kept for promotees.
Very well.
The 75% is equally a creation.
Of the judgment of this court,
No, there were, Shetty Commission has noted that there were reservations, varying reservations. Some states had them, some states didn't have them. They recommended that there should be uniform, and they said there should be an amendment. Shetty Commission said there should be an amendment to Article
The
233.
difficulty we tell you is this.
So
Yeah, mainly because whatever may be the quota, let us say 5%, 10% for the promotee. Unfortunately, the impression is once that the promoter, some vacancies are filled up, the remaining should go to the lawyers. We are saying where do you get it? Under the constitution, we are
I'm
trying to.
I'm saying, look, I'm answering your lordships. There are, let us say there are 100 posts. 233 says simply that there are 2 sources of recruitment for those 100 posts. 2 sources of recruitment, one is by promotion and one is by direct recruitment. Direct recruitment with the qualification 7 years as a lawyer, as a member of the bar, right? The 233 does not say that 1 or 2 or 10 or 20 or 75 should go to X. That division of 75-25 is in the prerogative of the high courts, as your lordships have said. I'm answering your lordship.
But the 25 will not go to you alone, that's what you are saying. That is meant for the open competition.
I'm saying that 25 is a factor of the same division from the 2 sources. The 2 sources being direct recruitment from the bar and promotion from the bench, from the subordinate judiciary. And that, whether your lordship say that it should be 10% to the bar or 100% to the bar, I'm saying that is in the prerogative of the state. In this case, the High Court, the governor in consultation with the High Court. That 75% is not carved in stone. 75% was not given to us by some preordained system. That 75 came from the same mechanism. So it either there is nothing, or there is a fixation of. So the basic argument, your lordship may overrule the argument, but let me at least not be misunderstood. The argument is that 233 only lays down the sources, nothing more, nothing less. Now, so far as the mechanism of implementing those sources, the proportionality in what proportion those sources should be exercised, that is the pure prerogative of the high courts in consultation or by rules made with the governor. That's my submission. That's why I'm saying those rules have been framed, and those rules provide for 25% quota. Unless your lordship strike down the rules as being ultra vires 14, 16 or 233 or some other provision of the constitution, those rules hold the field. They are 309 rules. That is the point which I'm making. The point may be your lordship, it may not find favor with the court, but let my
No, we understand.
now
We
I
get
think
your point, no problem.
I think that point has been made clear. Lord, so the rules your lordship may just note, Lord, that say Madhya Pradesh, for instance, the rules your lordship will find in volume 7. Yes, volume 4, volume 4, there are two, 4A and R. In volume 4A and R, at page 719,
You already taken 10 minutes of Mr. Gupta, so
just make a note of the rules.
you will have to curtail his time now.
No, my learned friend Mr. Gupta told me that to complete my point. So
He will have, his time will be cut down from that.
So my lord may just make a note.
Or the others time, whatever the choice is on that side.
Very well. If I can, I'll put it in a note, but my lord may just make a note. There are several rules, including Madhya Pradesh and Haryana, among others, which specifically provide for the quota. Kerala also provides for the quota. Your lordships are familiar with that. And also Madhya Pradesh, Haryana, among others, provide that if there's any vacancy which is not filled from the quota of the direct recruits from the bar, then, my lords, that will revert back to the promotees, and that will be filled from the promotees will get those leftover vacant seats. Kerala rules categorically provide, my lords, for continued membership of the bar. They say there are two separate rules over there which deal with membership of the bar and the qualification of 7 years as an
Mr.
advocate.
Jaidev Gupta has argued against that.
I'm sorry?
Mr. Jaidev Gupta, appearing for the state of Kerala, has argued.
The Kerala High Court in this case and the state lords, for whatever reasons, they may have their reasons, but this is a case, Rajneesh was appointed after this honorable court passed its interim order saying that that all previous appointments we are not interfering with for now because they are already serving. Hereafter, there will be no appointment made of anybody who's from the judicial service. In the teeth of that order, which was brought to their attention, they made the appointment of Rajneesh. In the teeth of your lordship's order. So his claiming equities and all is just not available to him.
We are not going into the individual matters now.
I'm sorry. So that is set out in the list of dates is at page 19 of volume 2. So your lordship may just make a note, Lord, my submission is that these rules hold the field unless your lordship strike them down. It's not a simple thing of consequentially rules vanishing, because pursuant to your lordship's directions, these rules have been framed under 309 and they are promulgated, they are notified in the gazettes, and they're holding the field. So they get a life of their own, because the directions of this honorable court. I'm deeply obliged. Because some points may be left out, subsequently your lordship may give some directions allowing us to file.
Already your written submissions are there. We don't want to flood it with again papers.
Which are in advance, your lordship know, because so many things fall from due to arguments developed by the other side or the questions fall from the court. We can deal with those.
Well, as I appear in 501.1 for the first respondent, High Court notes.
In 50?
501.1, I appear for the Punjab and Haryana High Court notes. I have given a detailed note of written submissions, Milits, which is in volume 2, page 43 onwards, but your lordship need not bother with it today, Milits. I'll orally make submissions to your lordship today, Milits, and I'll take your lordship to the written submissions tomorrow. Now, Milits, broadly I say this. 233, 1 and 2, both speak of appointment. There's no doubt in that. Both are speaking of appointment. Both use the word, Milits. One uses the word appointment, and the other uses the word appointed. 233.1 also refers to promotion. In what context we will see, but it refers to promotion. It uses the word promotion specifically. 233.2 is clearly referring to direct recruitment because it is talking of Milit's appointment from the bar. It is clearly doesn't use the expression direct recruitment, but it is Milit's clearly speaking about it. 233.1 uses the expression consultation with the High Court. So appointment is common. 1 speaks of promotion. 2 is dealing with direct recruitment. There is no doubt on that. One speaks of consultation. The second speaks of recommended by the High Court. 2 different expressions used, Milits, which have been considered by your lordship.
consider both in
Yes, yes.
Rameshwar as well as.
So, yes, sir. So these two expressions, this is what is very clear. It is my submission that one is for those who are in service and two is for those who are not in service. This is the submission.
According to 233, 1.
Is for those who are in service and 233.2 is for those who are not in service. How do we say that, Malitz? Is the question. And the real issue is whether 233.2 is exclusively for those who are not in service. That's the issue, Malitz, your lordship is considering. If the interpretation being canvassed by the other side is accepted, then 233.2 is clearly not speaking about those Malitz who are in service being permitted. 233.2 is making no reference to allowing those who are in service to be included here, from the words of it. It is an interpretation being given by what is being said is that since it's talking of those who are not in service, but there is no prohibition for those who are in service, therefore they can also participate. That's the Malitz way. But obviously, 233.2 is not directly referring to anybody who is in service. It is not speaking about it. This is very clear. Number two, what is also equally clear is that while 233.2, which is dealing with direct recruitment, is prescribing the qualification for those who are advocates, there is no qualification prescribed for those Malitz who are in service in 233.2. It's an important factor, Malitz, for the submission I will make. 233.2 is dealing with only direct recruitment. It is providing for a qualification for those who are advocates, that is not in service, but is not prescribing any qualification for those who are in service. So it is not speaking of those who are in service, number one, and number two, it is not prescribing any qualification. Ancillary to that would be the question whether it would be reasonable to say that just the way 233.1 speaking of promotion is not providing a qualification, it can well be that those in service in 2 are also not prescribed a qualification. 233.1 is not prescribing a qualification that is provided by rules. So can it be that 233.2 is also therefore silent? My submission is where direct recruitment is being considered, there normally there will be qualification for all those who will compete there. It will be incongruous that for one category who's applying for direct recruitment, there is a qualification, but for another category, which is applying for direct recruitment, there is no qualification. It will be incongruous, to put it mildly. Number two, Article 124 and 217, which I will advert to in detail tomorrow. While they speak of all the jugglery in certain cases, you can add this and that and that and this. You can add your time as a judge in the time as an advocate with certain conditions. Your lordships have in Rameshwar Dayal specifically said that in 233 you can't do that. That Rameshwar Dayal says so very clearly, which means you cannot then say that in 233.2 you have 3 years as a judge and you have 4 years as an advocate, etc. You can't do that here, is my submission. You can't do that. You can't then have the question, which is the fourth question, the second additional question issue, whether you can have some years here and some years there. In my most respectful submission, can't be done.
Yeah, I agree with you.
Yeah, that's an important part to answer the fourth issue. That's one important facet. Then
that was with regard to the number of years of practice in some other high court.
No, I will show that. Rameshwar Dayal has been completely misconstrued in what has been presented to your lordship. In my most respectful submission, and I will make it good from the judgment, Rameshwar Dayal upholds Harbans Singh and Sahni on the premise that they have been advocates for 7 years and they are advocates till their date of appointment as district judges. It says so in so many words. Let's see it straight away. Since it goes to the root of the matter, let us first see Rameshwar Dayal. And let us see, what is the rationale. Certain parts have been shown to your lordship and certain vital parts are yet to be shown, So I will repeat some parts, but please bear with me, It's an important part,
The part that you want to show is at page 112.
No, your lordship may allow me, to place it my way, but I will, show all those parts as well.
That is on the interpretation of the Lahore High Court
No, Militz,
Punjab order,
Militz, that also, Militz, that also,
Bar Council Act 1926.
that also, where they conclude that therefore they may not be on the rolls. The requirement is you should be advocates, and they were advocates. That is the rationale, and therefore 233(2). Therefore 233(2). That is what it says. And Chandra Mohan, I will show Militz, very clearly says only advocates can come under 233(2). Specifically uses that word, only advocates, and followed later on by another constitution bench, Militz, in 2004, is it? 2000, we'll show tomorrow. Now, Militz, kindly take Rameshwar Dayal first, Militz.
Yes.
Kindly come, Militz. The facts are well known, Militz, but kindly come to page, Militz, 104 in the volume before your lordship. I don't have my juniors, yes. Kindly come to the foot of the page, Militz, after they reproduce Article 233. Now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondent 2 to 6 fulfilled the requirement of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. That clause lays down that a person not already in the service of the union or the state shall only be eligible to be appointed by a district judge if 1, he has been for not less than 7 years an advocate or a pleader, and 2, is recommended by the High Court for appointment. I pause, Militz. Now, Militz, if your lordship sees 233(2), I'll just pause, Militz. This is an important line I want to rely upon. 233(2) says, a person not already in service of the union or so-and-so shall only be eligible to be appointed. And here they say, not already in the service shall only be eligible to be appointed district judge. 1, if he has been for not less than 7 years an advocate or pleader, and 2 is recommended by the High Court. Then, Militz, your lordship may, Militz, on the issue of has been, I'm not coming on that for the moment. Your lordship may skip that and come to the next page at page 106. And please see, Militz, clause 6 for a moment, the middle of the page. My lords have that, Militz? Clause 6 of the order is important and must be quoted in full. 6.1, Militz, is important. The High Court of East Punjab shall have the like powers to approve, admit, enroll, remove, and suspend advocates, vakils, attorneys, and to make rules with respect to advocates, vakils, attorneys, as are under the law in force immediately before the appointed day, exercisable by the High Court of Lahore. Right of audience, etc. Your lordship can skip. The page over, Militz, page 107. Kindly see again the lower half, section 8. Section 8, Militz, and your lordship may come to 8.2. The High Court shall prepare and maintain a roll of advocates of the High Court in which shall be entered the names of A, all persons who were advocates, vakils, pleaders entitled as of right to practice in the High Court. Please mark again, immediately before the date on which the section comes into force in respect thereof. So, Militz, whoever is entitled to practice, etc., immediately before is, Militz, to be mentioned. Then, Militz, your lordship may move down, Militz, 3 pages and come to 110. On a different point of 124 to 117, Militz, I'm reading sequentially, so I'll read it here so I don't have to come back to it. And the middle of the page is the new paragraph. Learned counsel for the appellant has also drawn our attention to explanation 1 to clause 3 of 2124. Relating to qualifications for appointment as a judge of the Supreme Court, and to explanation 2 of 217 relating to qualification for appointment as a judge of a High Court, and has submitted that where the Constitution makers thought it necessary, they specifically provided for counting the period of a High Court, which was formerly in India. Article 124 and 217 are differently worded, refer to additional qualifications of citizenship, which is not a requirement of 233, and we do not think that clause 2 of 233 can be interpreted in the light of explanations added to 124-217. 233 is a self-contained provision regarding appointment of district judges as to a person who is already, please mark this, Miller, this is very important. So this is one part, 124-217 you can't read. This is one part which is important. Now the next is also important. as to a person who is already in the service of the union or the state, no special qualifications are laid down under clause 1. The governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. Now, it may be said, Malaj, I'm arguing against myself, that while it is saying so here, they don't specifically say, no, you can't have other people. But they are not saying here that you can have other people, and I'll refer to other parts to buttress that submission. But here they say very clearly that clause 1 in service, clause 2 not in service. Then let's read further ahead, Malaj. The clause does not, Malaj, then this again is not so important, but kindly come, Malaj, to page 111, just about 10 lines from the bottom. This they are considering, Malaj, the other three gentlemen who were, Malaj, advocates at that time. Just the line starting, we consider it unnecessary. Malaj, about 8 lines from the bottom. My lords have that, Malaj? We consider it unnecessary to pursue this matter further because the respondents we are now considering continue to be advocates of Punjab Haryana as they were appointed district judges and they had standing of more than 7 years were appointed. They were clearly eligible for appointment under clause 2 of 233. Now, Malaj, we now turn to the other two respondents, Harbans Singh and Sani, whose names were not factually on the rolls of the advocate at the time they were appointed. What is their position? We consider that they fulfilled the requirement of 233 of the Constitution. Harbans Singh was in service at the time of his appointment. Vishwanath so-and-so, appearing for him, has submitted that clause 2 of 233 did not apply. We consider that even if we proceed on the footprint that both these persons were recruited from the bar and their appointment has to be tested by the requirement of clause 2, we must hold they fulfilled the requirement. They were advocates enrolled in Lahore, that is not disputed. Under clause 6 of the High Court order, they were recognized as advocates entitled to practice in Punjab High Court until the Bar Council Act so-and-so came in force. Under Rule 8.2, which I read to your Lordship, it was the duty of the High Court to prepare and maintain a roll of advocates in which their name should have been entered in the day on which Section 8 came in force. That is so-and-so, September 28, 1948. Proviso to subsection 2 on Section 8 required them to deposit a fee of ₹10 at the Bar Council. Obviously, such payment could hardly be made before the Bar Council was constituted. We do not agree with the learned counsel for the appellant that the interveners, that the proviso had the effect of taking away the right for these respondents had come to automatically on the roll of advocates under 8.2 of the Act. We consider that the combined effect of clause 6 of the order and 8.2 of the Bar Council Act was this. From August 1547 to September 2848, they were recognized as advocates entitled to practice in the Punjab High Court after September 2848. They automatically came on the rolls of advocate of Punjab Haryana High Court, but had to pay a fee of ₹10 to the Bar Council. They did not cease to be advocates at any time or stage after August 1547. They continued to be advocates of the Punjab High Court till they were appointed as district judges. They also had the necessary standing of 7 years to be eligible under 2 of 233. So, Malaj, very clearly, 1 is service, 2 is those not in service. 124.217 can't come here. And here they have been accepted because they are members of the bar as per the rules then. Maybe not under the Bar Council rules today because that's completely different. Suri's judgment sees that. But this is the ratio, Malaj, of this judgment. And they say, therefore, the necessary qualification of 7 years is met. That's what they say, Malaj, here. This is one part, Malaj. I'll continue tomorrow.